on hot topics in Adobe licensing, sponsored by Scott and Scott LLP. Your presenters, Robert Scott and Julie Machal-Fulks, are partners at Scott and Scott LLP, located in South Lake, Texas. Julie Machal-Fulks earned her undergraduate degree in English with honors from Texas A&M, Corpus Christi, and received her JD degree from the University of Houston Law Center in 2000. She has been a partner in the firm since 2009. Robert Scott studied philosophy and economics at Austin College, where he graduated summa cum laude. He obtained his law degree from Hofstra University School of Law in 1996. Robert and Julie are trusted advisors to senior executives in some of the world's largest corporations. They regularly advise clients on software licensing transactions and disputes with software vendors, including Microsoft, Adobe, IBM, Oracle, Autodesk, and many others. They serve as defense counsel in Adobe versus the Levi Group, currently pending in the Federal District Court for the Southern District of New York. Now let's get started. Here's Julie. Thank you.
Thank you again for joining. This is Rob Scott, and I will be handling the first part of the presentation, then I'll turn it over to Julie to handle the second half of the presentation. If you have questions along the way, please feel free to use the interface to ask your questions as we go along, and then we'll have some time at the end for Q&A. We'll start with the agenda. You know, one of the things that clients ask me frequently is, how did I wind up in a situation with an Adobe audit? And in many instances, the audit results from a letter that's being sent either from an internal organization at Adobe or from someone on the outside requesting that an audit take place. And it's not really clear all of the different avenues that Adobe relies on to identify audit targets. But one thing is for sure, that increasingly Adobe and other publishers are getting more and more sophisticated in their compliance activities when it comes to identifying targets and coming up with ways to develop leads. In many cases, organizations are running ads to attract disgruntled employees and former employees to make anonymous tips in exchange for reward money, and those tips result in what we call agency audits conducted by the Business Software Alliance and the Software Information Industry Association, also known as the SIIA. Both act under power of attorney to conduct Adobe audits. Adobe also, as I mentioned, conducts internal audits. If you are a small, you represent primarily small companies or involved with primarily small to mid-market sized companies, then agency audits would be a likely threat when it comes to Adobe audits. If you're a large enterprise, you would expect to have someone internal from Adobe and possibly aligned with one of the outside auditing agencies. Audit providers from the big accounting firms may be called in that large enterprise situation. The focus of Adobe audits is really around taking a snapshot of what the target's current license compliance status is as of the date that the audit is announced. What that means is basically the audit is announced on a particular day, and then an investigation ensues to understand, based on a snapshot in time, what products, Adobe products, are installed within company computers versus what license entitlements that company has purchased to offset those licenses that have been deployed. And that's the primary focus of an Adobe audit, although we're also finding that there is an increased focus on the DMCA, which is the Digital Millennium Copyright Act, which includes a provision in it that deals with anti-circumvention. And what it really is focused on is creating an increased copyright penalty for infringement that results in the passing of any kind of a cracked key code or any kind of a hacked code or any kind of accessing of utilization of technology that would allow you to access the products without having a license. And so the focus of these Adobe audits is not only present license compliance, snapshot in time, but also we're starting to see Adobe asking for factual information and investigating whether or not there's evidence that there could be a DMCA violation associated with the use of cracked or other keys at the time that the installation is made. Very recent and significant development, because the DMCA carries civil penalties under statute and under certain circumstances can carry criminal penalties as well. This dovetails nicely with regard to the theories of liability. Most software cases are predicated on a copyright infringement type theory of liability that's predicated on the scope of the license entitlement that's granted in the software license agreement. Said another way, the license agreement establishes the contours for which the user is able to use the software, and anything that's beyond the permitted uses by license would constitute a copyright infringement claim. So in most cases, you're dealing with the licensing agreements and applicable rules, and then how those interplay with copyright law, both copyright infringement and also, as I mentioned, the Digital Millennium Copyright Act type claims. We see also in the context of the small enterprise market theories of vicarious and respondeat superior liability. So in cases that have gone to court, we sometimes see where Adobe will name not only the company and its affiliates, but also its principals, and allege vicarious or respondeat superior type liability based on a copyright theory that says that, unlike state law theories, if in the context of a copyright infringement case, the copyright holder is able to establish that a principal had the ability to control the infringement and there was a financial benefit, that the existence of those factors is sufficient under federal law, which would preempt state laws that have state protections for doing business in various corporate entities, would be trumped under the supremacy clause when it comes to copyright infringement. So we're seeing on theories of liability, kind of the new trends are the breach of contract and the copyright infringement has been there. There's nothing really new there other than some wrinkles around how the disputes are getting valued, which we'll talk about some more. But really the new things here are what we're seeing: DMCA liability claims, as well as vicarious and respondeat superior contributory theories of liability under copyright. The audit provisions are very important. You know, most of the major publishers have some sort of agreement in their license terms that sets forth when and under what circumstances they can audit. And we have found that in many cases that we're working on, that the actual audit requests that are being made in the context of the audits go far beyond the audit provisions in the agreement. So that, for example, the audit provision may say that we'll share an analysis or information regarding the software usage, and then we get bombarded with requests that really don't have anything to do with that kind of reporting, but in our view and the view of some of our clients, really are more in the form of a fishing expedition into other factors and oftentimes into factors that may go to establishing Dmca type theories of liability on the basis of evidence that perhaps cracked codes or other installation techniques have been used that could become problematic. So it's always important to understand in any audit matter what the actual language is of the audit, because you definitely don't want to be in a situation where you have a publisher that's engaged in a contractual audit and by practice or concession you wind up significantly broadening the scope of what types of information will be shared or the scope of the audit, because generally we like to keep the audit scope as narrow as possible for a number of reasons. Most important is just total cost in terms of operational and organizational impacts of dealing with a broadened scope, particularly if a product like Adobe is deployed on desktops that could be difficult to investigate, for example. The number one thing that most clients come to us for is they know they've got a problem with Adobe. They know what the problem is in many circumstances, at least in general terms. In many cases, they've received a demand from Adobe, and they know that they don't agree with it. In some cases, they've had a third-party auditor come in at Adobe's behest, and they come up with a report that they know they don't agree with, but they get stuck at that point in the process where it's, how do we respond? What is, they say we owe them $1 million. We don't agree with that. But what is the right number? What number would we agree to? And how would we substantiate that number, whether it be for purposes of making a counterclaim or assessing the value of the dispute for internal planning, financial planning purposes, could be to create financial reserves, could be for a number of reasons. But I would say valuing the dispute is one of the most important things that we do, and we'll talk in some detail about how we go about that. But the basic essence of the core of valuing the dispute is having a good factual investigation that reveals the full extent of the deployments of the software, both in terms of the total number and the actual versions that are installed on the total number of computers, as well as what license entitlements exist, and building an effective license position, or what we call a license reconciliation or gap analysis, to really show you, okay, this is where you stand. This is what you have deployed. This is what you purchased. This is what you have as a gap, and then applying a formula to create a financial model that shows you what is the potential financial exposure based on this factual picture. And in that situation, we'll be calling on our experience in other matters, the types of calculations that the publishers or the agencies will use, so that we can provide visibility early on as part of an early case assessment to demonstrate, okay, these are the facts that are relevant to the dispute, and this is what we think the potential penalties are. The other area where clients rely on us pretty heavily is after they've had one or a handful of audits and they start feeling the pain of audits, they will frequently come to us and say, can you guys give us advice on how to set up our software asset management program? Can you benchmark for us the maturity level of our current processes? Can you help us review and evaluate tools or other strategies that you can recommend to us so that we can manage our licenses more effectively in the future? Because there's definitely a pattern that has emerged where the publishers come, they press for information, the targets, for a variety of reasons, are not armed with all of the information that they need. And then the targets wind up being on the defensive. And when they're on the defensive, now they're talking about compliance and those types of things, and not really effectively managing or optimizing their spend in terms of license costs. So we'll talk a little bit about how to manage compliance and what types of things we're seeing our clients that are doing very well at it, how they've done it, and hopefully you'll get some takeaways to help you manage these risks better as we go forward. How are audits initiated? Well, I would say the vast majority of the Adobe audits are initiated through the trade groups, the Business Software Alliance and the Software Information and Industry Association. You may have heard whistleblower-type radio campaigns in various markets throughout the United States, or seen advertisements in trade publications or online sources targeting turning your boss for piracy. There are some of the campaigns are called No Piracy, but they all have a common methodology that was invented in the early 90s in 1993 by the Software and Information Industry Association, when they just decided to start sending out letters targeting people that they suspected of having more member software installed on their computers than they had licenses for. Well, very quickly they realized that this was a very successful approach, and then when the Business Software Alliance split off from the Software Information Industry Association, primarily under the impetus of Microsoft's desire to have greater control of the group, then the Business Software Alliance began running the same model. And since then, there's been a cat and mouse game between the two, marketing for what they refer to as piracy leads, and offering, at one point, I think the high water mark was $1 million in reward money that's being offered to employees and disgruntled former employees to turn their companies in if they have information that would lead them to believe that the companies have more Adobe software installed on their computers than they have licenses for. And as I mentioned, the best way to think about Adobe's strategy across these audit types is target company size. So if you think about the SMB market, that's really BSA's domain. They're going to be after the companies with 2 to 200, 250 computers. The mid-market is really the SIIA. They're really going to be focused primarily in that 100 to 1,500 computer range. And then when we get into enterprise or even large mid-market, you're going to see internal teams at Adobe initiating the audit requests. Now, some of the differences between an internally initiated audit by Adobe versus an agency audit is that Adobe is going to have more flexibility to negotiate a combined deal that includes both resolution of any past compliance issues as well as the acquisition of new licenses. While the BSA and the SIIA both have power of attorney to conduct enforcement activities for Adobe, neither of them are engaged in selling any software, in the sense that you could have a negotiated resolution that would include historical compliance and current licensing needs as part of the same settlement. Typically what happens is any past compliance claims or settlements are paid to the agency. They keep that money, and then as part of the settlements, there's a requirement to come into compliance and demonstrate present compliance, and presumably the publisher, in this case Adobe, would benefit from that, but it is more a byproduct of the settlement terms than actually where they're a beneficiary of any direct funds that are being paid at the time of settlement. So what is the real focus of an audit? First and foremost, if Adobe is coming in to audit, or you want to conduct a proactive audit or have one conducted, the first and foremost is, what is the license compliance status? how much software do we have installed on company-owned computers, and how did it get there, and what kind of license entitlements do we have that we could take to court or use in defense of an audit that would be considered acceptable proof of licensing. Some of the areas that we see clients getting into trouble in these audits include where we have desktop software. For example, Adobe makes a lot of products for the desktop. The Acrobat is probably, one that is heavily focused around desktop users. There's a number of different flavors of Acrobat. It can range from a free reader but into pretty sophisticated applications that are somewhat pricey. And what we see people doing is installing them on servers and then allowing multiple users to access that server deployment in circumstances where those end users are not licensed. So you can run into a big multiple of installs. Your financial liability can be pretty significant because it's going to be calculated on the number of users, not necessarily based on installs. So wherever you have an install with multiple users, that is usually a hot issue for potential compliance. We also see a lot of over-deployment of the desktop software in desktop environments. I would say primarily Acrobat, but also the Creative Suite products are frequently over-deployed, I think in part because they're expensive. But we're talking about with Creative Suite, we're talking about Photoshop and Illustrator, primarily the core products being bundled together there. Both even independently are pretty expensive, and the Creative Suite, together is very expensive. And so we're looking at not only what software is out there, but whether it was deployed from a Creative Suite disk or from the disk that was the component part. And we'll talk a little bit later about component versus suite-based pricing and the implications on copyright law, where the Copyright Act says that a compilation is entitled to one measure of damages, and Adobe and many other publishers argue that if you install Creative Suite, they're entitled to recover for infringement of each of the component pieces of the software, not for the compilation. And the difference on that particular legal point can represent hundreds of thousands, if not millions of dollars of a particular case. We could talk more about that as we go along, but Adobe, like Autodesk, the focus is often around serial numbers, file paths, and other information that goes to the authenticity of the source of the installation medium. And we see this a lot with these two publishers, and generally what these serial numbers will show is what was the installation pattern within the organization. If, for example, the same serial number is showing up on multiple computers, that's a pretty good sign that a compliance issue was created. So that, coupled with invalid serial numbers, some of this circumvention codes and hacks basically pass serial numbers that are non-authentic. They function, but they're not authentic, and the publishers know which codes were issued by them and which ones are illegal crack codes, and that's why they're asking for this information. I've never seen anything good in either an Adobe or an Autodesk case come out of disclosure of serial numbers. So it's something that we generally advise our clients, particularly in Adobe cases where the audit provisions fairly clearly indicate that it's not required to share. We generally prefer not to share that information for those reasons. This idea of what is piracy and what is pirated software, it's kind of a very loaded term, but I think it's generally accepted today, and even I would have difficulty arguing it, that if an employee deliberately takes a code that it knows to be an illegitimate code and it passes that code in order to authorize or install or deploy software, that's going to constitute piracy in the sense that it would clearly violate the digital millennium copyright provisions that go to anti-circumvention and circumvention of compliance controls. And this is an increasingly hot issue in Adobe cases. We've had this issue in litigated cases that we've handled, both involving Adobe and with Autodesk and other publishers. So this is definitely something that needs to be on your radar screen, that it's not just about the license reconciliation, but it's also about how the software got there. And if it got there in a way that violates the Dmca, you'll be looking at increased settlement demands, increased financial exposure over and above what some would argue are exorbitant claims for damages based on the compliance allegation. So copyright infringement is a creature from a theory perspective of federal law. There is exclusive jurisdiction in the federal courts, meaning unlike in a trademark case where there could be both a federal and a state trademark case, in copyright law there are no state theories. All copyright theories are federal theories of recovery, and that's why you see in the cases that we've dealt with in these areas are almost exclusively dealing with federal court cases where the main theory of recovery is copyright infringement. Direct copyright infringement is generally targeted at the company and or individuals within the company that were the primary actors in taking the steps that constituted the alleged infringement. Vicarious and contributory theories of copyright infringement are also regularly pled in these cases, and they're generally targeted at the principals of companies in order to hold them in on a multiple defendant type strategy that names not only the companies but the individuals that are involved in the management or the principals of the company. We talked about Digital Millennium Copyright Act and circumvention there. One thing to point out there is there are statutory damages under that, and it's a per infringement statutory damage model, and so the dollars can add up really fast if you've got a situation where you've got people, putting out ghosted images, for example, where the original source disk may have been from a cracked code. You can wind up with significant number of potential Dmca circumvention claims in this context. The last theory, which is really in order, breach of contract, is almost never an important theory of recovery in a software case, primarily because the breach of contract damages and theories of liability in terms of burden shifting and otherwise are not nearly as good as copyright. A lot of my clients are upset by the amount of work that they have to do to disprove that they haven't done. They have to disprove claims of compliance, and one of the challenges that we have to disabuse them of is that in a copyright infringement case, unlike in a breach of contract case, your burden shifts very early in the case to the defendant to come forward and prove that they have a license. So the copyright holder need only come forward and prove that they own the copyright. And if they own a copyright, then the burden shifts to the defendant to show they have a license. And so things like ambiguities in the license don't help you in a copyright infringement case necessarily, where in a breach of contract case, in many jurisdictions, absent a writing to the contrary, the ambiguities would be construed against the drafter, particularly in contracts such as license agreements of these types, where you don't really necessarily have a negotiated exchange, you don't necessarily have signatures, and so forth. So ambiguity, my contracts professor in law school used to teach me that ambiguity is your friend, and that may be true in the contract context, but in copyright infringement case, because the defendant has to establish entitlement to the license, a lot of times ambiguities in the license are not that favorable to the defendant. So because of the theories of recovery, because of the way the burden shifts, because it's exclusive jurisdiction in federal court, because there are better damages rules, and because there's a public policy favoring inventions and protection of copyright holders, most cases get pressed on copyright infringement theories, and that's why we have the breach of contract theories here at the bottom. Now, that doesn't mean that the license agreements themselves are not critically important, because they are, in that they define, in the example that I gave you, they establish the entitlement to the license. And whether or not a particular deployment or particular product has been properly licensed, in the first instance, will have to be based on an interpretation of the contracts and the license agreement. So increasingly, our clients are seeing an uptick in the number of their vendors that are calling to the audit provisions in their license agreements and requesting that an audit be conducted, whether they refer to those as compliance reviews, license reviews, audits, FAM engagements. There's a number of terms. They all, to me, basically mean the same thing. It's an audit of some sort of flavor. It involves an investigation of the target's license compliance status, and almost always some sort of a demand for payment of some amount on the back end. The basis for the request will be based in the software license agreement, typically in the end-user license agreement from Adobe, or in any kind of enterprise-type agreement, which will set out the basic terms and conditions under which Adobe can audit. Terms are generally that they have the right to confirm compliance and to request information regarding the accuracy of the compliance status, including requesting certain reporting regarding deployments and entitlements, and often contain, a relatively short time frame to respond. I generally find that it takes a lot longer to respond to audits than the publishers think it should. Generally, a lot of information needs to be gathered, and it's not readily acceptable, and it's not, contrary to what some might believe, that easy to count these things, because they can be complicated by difficult licensing rules, or maybe difficult to identify what's actually installed. So there's quite a bit of work to do, and 30 days, even for a relatively small company, is a very aggressive time frame to complete an audit. In many instances, the provisions in the audit will talk about what the remedies will be in the event of noncompliance. In some instances, they'll talk in terms of if a greater than 5 or 10% gap is found, then the publisher will have greater rights to recovery, including recovery of audit fees and so forth, versus a situation where the compliance level at the end is less than 5%. In many cases, it's important, particularly in the large enterprise context, to look for negotiated or customized audit provisions, because the clients that we have that are larger, have greater bargaining power, are beginning to use that bargaining power to get into more balanced and more favorable license agreements where the relationship can be managed in a less adversarial way. And so what we find ourselves doing as part of enterprise deals or as part of settlements, is negotiating new licensing terms which either significantly water down audit rights or eliminate them altogether in the form of forbearance agreements or other true-up mechanisms where there's no need for an audit. So you want to look as you're diving into when I deal with an audit, one of the first questions I want to know is, under what agreement are you purporting to audit? Did my client sign that agreement? Because there may be formation issues that need to be addressed or pressed. And what are the terms of that provision with regard to scope of which part of my client's organization does it include, which products are in question, how far back can it go? All of those issues around scope are early on issues to address, and you want to address them in terms of understanding what is the agreement and what specifically does it say. With that said, I'd like to pass the slide deck to Julie and have her get into what I've described to you guys really as the meat of the services that we provide, and really the important aspects of understanding in a situation you've got an audit or you're unsure about your compliance situation and you want to get an understanding of what the order of magnitude is of that problem, then this is the strategy that we use. These are the processes that we follow, and anybody that would want to undertake these activities to get to these same answers would want to follow these same approaches. So I'll also be available at the end of the presentation to answer any questions that you may have, but for now I'd like to turn it over to Julie.
Thank you, Rob. One of the biggest components of preparing yourself to respond to an Adobe or really any software audit is making sure that you understand the financial implications of the materials that you are preparing and that you're planning to submit to the other side. So once you've gone through the process of evaluating the audit provision in the relevant license agreement that Rob was just talking about, and once you've ensured that you have secured a document that protects your interests, whether that be a confidentiality agreement or an agreement pursuant to Federal Rule of Evidence 408 that governs the production and the management and the potential dissemination of any of the materials that you might provide, then it's time to really start critically evaluating the deployment information, the entitlement information, how those two sets of data work together to determine what the potential exposure might be with respect to the Adobe audit. So the first thing that you have to do is determine what kind of information is the auditor requesting, and are you required to produce the information that the auditor is requesting. So in an SIIA or a BSA audit, the auditors are typically requesting merely a cumulative report of the Adobe and other software products that are installed on the network. And so it is typically in those cases not required that you present to the auditors the raw data that formulated the basis for the report that you're ultimately going to generate. If Adobe is preparing or requesting the audit directly, it is important for you to determine whether any internal auditing tools that you have in your environment will be acceptable to Adobe, or whether you are going to be required to supplement those internal tools that you might have in your environment with additional tools. So for instance, a number of my clients have FCCM or other network deployment and inventory tools available to them, but they may not know how to extricate only the Adobe materials, or even if they can isolate particular software deployments to one publisher, they might not know how to collect all of the information that Adobe is looking for. So Rob mentioned earlier that Adobe is often looking for file paths, for serial numbers, and for other information that might lead Adobe to believe that even if you have a license for the Adobe software that you have installed, that the software itself is pirated or otherwise installed improperly. Adobe may ask you to run scripts and produce the unedited output of the script. The Adobe license itself says that the reports that need to be produced must be unedited reports, although it typically does not specifically use the word script. And so Adobe may also ask for manual discovery that's typically related to questions about the servers and whether desktop server products are loaded on the servers. The challenges with collecting the deployment information, first of all, if my client is a multinational corporation, it is sometimes extremely difficult in non-centralized environments to even get the outliers in Kuala Lumpur or in the Philippines to collect the data that's necessary to try to provide to Adobe. So the first thing that you need to do to address a challenge with deployment information is determine whether you can limit the scope to those parts of the organization that are easily inventoried. The Adobe license agreement typically says that the audit must include the company that is the party to the Adobe license agreement and any of that company's affiliates. And so Adobe's position is all of the affiliates worldwide need to be included in the audit results, but sometimes it's simply not feasible and will exponentially extend the period of time that it will take to respond to the audit. Sometimes the audit tools are unreliable and present, for instance, the older versions of the Acrobat free reader show up as the full version of the Acrobat product. And so it is often necessary to make sure that the data is validated before it is submitted to Adobe or any of the Adobe's representatives. The other issue is that in many instances it is impossible to tell whether the Creative Suite was installed as a bundle or whether the components of the Creative Suite were installed individually, which could be important to determining damages. Additionally, it's important because it may be the case that you have a license for the Creative Suite master collection, but the inventory data for that particular computer will show only the 8 products that comprise the collection. And finally, you have to make sure that if we have a situation where there are a number of products that are spread out over several desktops, that folks in the organization are not violating the license agreement by installing a couple of the components from the Creative Suite on several different computers, which is prohibited by the license agreement. So it's important when valuing disputes to make sure that you're getting accurate and complete deployment information, that you are only collecting deployment information for those entities that are covered under the particular license agreement that is the subject of the audit. You need to make sure that all of the information is validated and reliable before submission to any of the opposing parties, whether that be Adobe directly or the BSA or the SIIA. The next step in the process is reviewing the entitlements related to Adobe purchases. I think that the majority of my clients struggle with this component of the dispute valuation because there are a number of different challenges that I'm going to talk about in a moment regarding the entitlements. But to review the entitlements, what you have to do first is gather all of the internal information and documentation that you have from your own procurement department. Make sure that you reach out to your vendors to get any entitlement records, and if you've switched vendors, make sure that you go back historically to get all of the documentation that you can get to demonstrate ownership, because Adobe's records may not be complete and probably are not complete with respect to your purchases, and you need to make sure that you can prove that you bought everything that you own. Additionally, you need to determine any sources of license documentation that you may have that aren't necessarily a proof of purchase. So for instance, if you have a registration confirmation from Adobe with a date on it, that is often sufficient to demonstrate ownership. There are also license documents, license confirmations that companies often acquire that can be used in lieu of a dated proof of purchase to demonstrate ownership. Some of the entitlement challenges that I see are that the records are incomplete, either because there's not a centralized procurement office that's responsible for obtaining records. Just yesterday, I had a situation where a client told me they were going to have difficulty obtaining records because their reimbursement requests for employee reimbursement for software purchases only went back 2 years, and some of the products they have been installed for more than 7 years. So pursuant to both the IRS record-keeping requirements and their own internal document retention policies, the company simply doesn't have records where employees purchase software and then requested that the company reimburse them for those software purchases. It's going to be very difficult to identify and find those particular license documents. In some instances, either because the company is spread out over multiple countries or because the company is in acquisition mode and is acquiring a number of subsidiaries, it is difficult to determine whether the records ever existed, and if so, where they're located. And finally, it's very difficult to find records if your vendor is out of business or if your vendor only keeps your license entitlement records for 2 years. So it's important that when you're selecting a vendor for any software product, that you're talking to the vendor about how long the vendor keeps records and what kind of reporting the vendor can provide to the organization in the event of an audit. That's one way to help tackle these challenges that we have with record entitlements. To centralize the purchasing, make sure that all of the records go through one or a very small number of vendors, and make sure that in the event that you are audited and you are tasked with the responsibility of identifying and producing the entitlement records, that you scour both the traditional avenues in finding those records and the non-traditional ones. With respect to the settlement and release, it is important to make sure that you've reviewed the original license agreement to determine what the potential remedies and ramifications are of the audit. As Rob mentioned a moment ago, some provisions in the audit clause in a license agreement are customized. I have seen vast differences in Adobe license agreements and resolutions ranging from the possibility where the company that's being audited can remedy any over-deployment by buying discounted software from the reseller of its choice. I have seen where the remedy is that the software has to be acquired from Adobe directly at retail prices, and I've also seen penalties like the ones that Rob described if the audit demonstrates that the company is more than 5% out of compliance. Then the company is responsible for not only purchasing the software at full retail price, but also responsible for paying any penalties associated with the auditor's fees in the event that Adobe used KPMG, Deloitte, or Pricewaterhouse for the audit. So it's important to make sure that you have a clear understanding of what the audit provisions in the license agreement say, what any listed remedies are, so that you have the strongest case available to you about how to resolve the audit. And it's really important to make sure that you get a release as a result of the termination and resolution of the audit. You want to release from Adobe of all the claims that were covered under the audit. I'm beginning to see that this is more and more important because now we're starting to see companies that are getting to the second cycle of audits for Adobe. So we have a company that companies that have been audited by Adobe in the past. They obtained a release. Now there's a new audit from Adobe, and the question is, will the software that was installed 5 years ago that was the subject of the release continue to be relevant for the current audit, even though it arguably has already been released. So it's important to make sure that the terms of the release are clear enough to ensure that future audits in a time period where the software may still be used are, it's clear that those are out of scope. What are the potential penalties in the event that the discussions break down and you are not able to reach a resolution with Adobe? One of the things that you need to make sure about if you're deciding whether to take a hard line with Adobe or any other publisher is you're aware of what the consequences are in the event that you and the publisher are not able to reach a resolution. In my experience, the publishers are not afraid to file lawsuits to enforce their rights, and they will do so asking for a range of penalties that they believe that they're entitled to. In some instances, they use their discussion of the potential penalties as an opportunity to present a picture that may be much scarier than it should be. But it's important for that reason that companies that are targeted by Adobe and other software publishers know what the potential penalties are and know how they'll be calculated so that we can determine in those instances what kinds of strategies we'd like to take. So the first set of potential penalties are under the Copyright Act. The copyright owner has the ability at any point up until the trial to elect actual damages for copyright infringement or statutory damages. Typically, actual damages will not afford the copyright owner the same range of damages as statutory damages. So in many instances, I see the copyright owners arguing that they're entitled to statutory damages. The statutory damages typically range from $750 on the low end to $30,000 on the high end, and that a judge could depart downward to as low as $250 per work or as high as $150,000 per work for instances where there was no knowledge on the low end or whether the infringement was willful on the high end. The judge has pretty big discretion to determine where in the range of damages the penalty will fall, but the software publishers typically like to take the worst case scenario when valuing the product. So for instance, in the case of the allegedly pirated software that Rob was talking about earlier with pirated codes or cracked codes, I've heard the publishers, including Adobe, say we're entitled to $150,000 for every installation of that product. The Copyright Act is pretty clear that it's not based on installations of the product, it's based on the titles themselves, but that could still be a scary number depending on how many titles are found to be in a particular environment. Additionally, there may be damages under the Dmca if the Digital Millennium Copyright Act, if the publisher can demonstrate that there were products in the environment where the code or the serial number that was entered was illegitimate or otherwise cracked, because that would arguably constitute a circumvention of a technological control that was designed to protect intellectual property. The most common penalty that I see, because many of the cases don't result in litigation, is that the publishers, including Adobe, argue that the company that's the target of the audit does not get to take advantage of any historical discounts and has to pay the full retail price of the software for any over-deployment. I also see arguments and requests and demands for auditors' fees, attorney's fees, and sometimes contract damages. So it's extremely important to make sure that you understand the value of the case before you make any strategy decisions that could impact the outcome. So to manage future compliance, you want to make sure that you are protecting yourself in advance of an audit by using confidentiality agreements with your employees to help lessen the risk that your employees might turn you into auditors. Make sure that you have software use policies that prohibit both the use of cracked or pirated software and the installation of any software for which the company does not have a license. Make sure that you are routinely auditing the company to ensure that any license compliance gaps are being cleared up before there's actually an audit on the table. Ensure that you have mature record retention policies to make sure that you can respond to an audit. If possible, restrict the administrative rights on the computers so that folks do not have the opportunity to install illegitimate software. And I do get a lot of pushback on locking down the computers. People tell me our folks need the ability to make sure that they can install anything that they want, but that obviously opens the company up to risk. And then identify authorized vendors that can help keep track of the products that are being acquired. That's some of the ways that we use to manage future compliance. And we have just a couple of minutes left. We are ready to address a few questions. Bear with us for just a second while we pull up those questions. So one of the questions that we have is, could a contract limitation on liabilities limit the statutory damages under the Dmca? I don't see why not. Rob?
I agree with you, Julie. I think you could create by contract as much as a full waiver of any damages under copyright. If you would do that, if the publisher would agree to it, in my experience, those types of provisions would be difficult to get from the mainstream publishers, but it certainly would be worth asking for, and I think in most situations it would be enforceable.
The next question is, what are the key issues associated with cloud-based subscriptions, and how does Adobe's cloud-based subscriptions impact Adobe's audit and compliance efforts? Essentially, how would they conduct an audit?
That's an excellent question. I think that when you're dealing with cloud, the focus shifts from compliance risk and infringement risk to security, data privacy, and business continuity risks. So I think, in terms of the cloud offerings, which are coming out, and everybody's got a cloud offering, and what we see when we're negotiating cloud deals is less of a focus on compliance concerns and more on regulatory compliance around privacy, security, customer information, what happens in the event of a breach. So the legal focus somewhat shifts. As far as how these subscriptions are managed, in many cases, you've got a certain amount of deployments based on the subscription, and the publisher is responsible for only provisioning the amount of software that you've purchased.
Okay, I think that is all the time that we have for today. Please remain on the line so that you can receive the CLE numbers from Anita. And if you have any questions that you've sent that we didn't have an opportunity to answer on the presentation today, we will address those offline if we can. Thank you so much for attending this presentation of Hot Topics in Adobe.